Former Transport Minister S. Iswaran's third attempt to compel the prosecution to provide all witness statements to the defense has been unsuccessful. On Tuesday, the 3rd of September, Iswaran, who was once a prominent member of the People's Action Party, sought to bring two significant legal questions to the Court of Appeal. These questions revolved around whether the prosecution is obligated to include all witness statements as part of its case and whether the court has the authority to order the prosecution to do so. According to the Criminal Procedure Code, the prosecution is required to serve the defense with its case before the trial begins, including any conditioned statements that it intends to admit during the trial. Conditioned statements are written statements that can be used as evidence in criminal proceedings. The prosecution has interpreted this requirement to mean that only conditioned statements of witnesses they plan to admit at trial need to be provided. However, senior counsel Davinder Singh, representing Mr. Iswaran, argued that the prosecution should also be required to provide all forms of witness statements, including draft statements, that it intends to use. The Court of Appeal, consisting of Chief Justice Sundaresh Menon, Justice Woo B. Lee, and Justice Stephen Chong, dismissed Iswaran's bid, determining that the questions raised by the defense did not constitute matters of public interest law. During the hearing, Chief Justice Sundaresh Menon and Justice Stephen Chong expressed difficulty understanding Mr. Singh's arguments. Justice Chong specifically questioned the admissibility of draft statements, stating that it is impossible to intend to admit such drafts, given their preliminary nature. Chief Justice Menon further challenged Mr. Singh's interpretation, suggesting that Mr. Singh's reading of Section 214(1)(d) of the Criminal Procedure Code would require the prosecution to include all witness statements, whether signed or in draft form, when filing their case, even if the prosecution did not currently intend to use them at trial. Mr. Singh argued that the intention to admit evidence can be formed or withdrawn at any time and that the law should not depend on the timing of the prosecution's decision to form that intention. He recalled that on the 2nd of April, the prosecution had asked the defense to consent to conditioned statements being filed without allowing them to see those statements first. When the defense requested to see the statements before consenting, the prosecution changed its position and decided not to file conditioned statements. Mr. Singh used this example to illustrate his point that intention is a moving target. Chief Justice Menon acknowledged Mr. Singh's points but noted that the language of Section 214(1)(d) of the statute is not flexible or open to interpretation in the way Mr. Singh suggested. He emphasized that the language of the statute was chosen by Parliament and constrains what the court can order. The Chief Justice also questioned where the statutory basis could be found to support the broader scope of discovery that Mr. Singh was advocating for. Justice Stephen Chong added that Mr. Singh's argument, suggesting that his client has fewer rights under the current criminal disclosure regime compared to the previous committal hearing provisions, was not a realistic one. He noted that the prosecution would disadvantage itself by not admitting certain statements if they were critical to their case. Chief Justice Menon also pointed out that Mr. Singh was essentially asking the court to craft a discovery regime similar to what existed under the old committal hearings, which would be problematic because Parliament had not intended to address this in the new regime. The trial for Mr. Iswaran is set to begin on the 10th of September. He faces a total of 35 charges, including 32 counts of obtaining valuables as a public servant, 2 counts of corruption, and 1 count of obstructing justice. The charges relate to his interactions with property tycoon Ong Beng Seng and Lum Kok Seng, the managing director of Lum Chang Holdings. The allegations involve Mr. Iswaran's receipt of various items, such as tickets to the Singapore Formula One Grand Prix, football matches, and musical shows in Britain, as well as other valuable items, including bottles of whiskey, golf clubs, and a Brompton bicycle. If convicted of obtaining valuable items as a public servant, Mr. Iswaran could face a prison sentence of up to 2 years, a fine, or both. Conviction under the Prevention of Corruption Act for corruptly obtaining gratification could result in a sentence of up to 7 years in prison, a fine of up to 100,000 Singapore dollars, or both. Additionally, if convicted of obstructing justice, he could be sentenced to up to 7 years in prison, a fine, or both. This case raises important questions about the rights of the defense under Singapore's current criminal disclosure regime and the extent to which the prosecution must disclose evidence. It remains to be seen how these legal debates will unfold as the trial progresses. What do you think about this case? Should the prosecution be required to disclose all forms of witness statements to the defense, or is their current practice sufficient? Share your thoughts in the comments below. Thank you for watching. Don't forget to like, share, and subscribe to our channel, 2230, for more detailed news coverage. Let us know what you think about this case in the comments below. Do you believe that transparency in the disclosure of evidence should be expanded, or do you agree with the current statutory interpretation? We look forward to your thoughts and discussions.